to have this program today. As we are just mentioning, it's a very timely program, I should say. Of course, we are all passing through a very challenging times now, and our heart goes to all those people who have been undergoing tough times and who have gone through tough times, losing lives and things like that. And let us all pray that things improve and come back to normal soon. And just for the benefit of the speakers here, because most of the members know us, the chamber is a 185-year young chamber. We have been the oldest chamber of the southern India and the second oldest in the country. And we have been known as a very proactive and very versatile chamber. And we have a lot of expert committees who support us with as think tanks in different domains. And this particular program, we thought primarily out of this IT committee. And in fact, I should say the starting point was for this program was the article written by Mr. Vaitishwaran, the moderator and our general committee member here. He wrote a beautiful article on the paradigm shift on the internet rules. I don't know, it could have come 3-4 months back or 2-3 months back, probably. So we thought this is one topic because the chamber takes up a lot of such points, what we call as a food for thought programs, where we take topics of great interest with varied views, diverse views, and try to deliberate on that for the benefit of members. So this is one such program. We thought about it, and today we are here to discuss that. Probably I recall that article, what Mr. Vaitishwaran said, and concluding remarks, he said, if a foreign chef wants to make a creative dish, and if all the regulations, if all the comments monitoring comes, and all the changes happen, what the dish would be at the end of the day. So let us wait and see what the program would be at the end of these 2 hours. Let me take pleasure in welcoming all the 3 speakers. Ms. N.S. Napinai, Advocate, Supreme Court of India and founder of Cyber Sati. Welcome you, ma'am. Mr. Rajendran Dandapani, Director of Engineering, Zoho Corporation. In fact, in all these gloomy days, we were hearing a lot of cheerful and positive news about Zoho. Congratulations and welcome you, Mr. Rajendran. And Mr. Pranesh Prakash, Policy Director, the Center for Internet and Society, Bengaluru. So we take pleasure in welcoming all the 3 speakers and our seasoned moderator, Mr. Vaitishwaran. As I said, he's part of our General Committee as well. And of course, Mr. Ashok, the Chairman of our Expert Committee on IT, and Ms. Savita, Mr. Srinivas, the Co-Chair of the committee, Savita, part of the IT committee and the Co-Chair of the Legal Committee, and all the members who have joined together today to listen to this deliberations. I know it's on a Saturday morning, it's a bit tough, and WebEx is also not a very easy platform, but we think that could be a more safer platform. So we prefer to go through that. So thank you so much once again, and without further ado, I would request Mr. Ashok to set the context, which will be followed by Ms. Savita, who would introduce the speakers in detail, and then I will leave to all the panelists and the moderators. Thank you. Have a wonderful, safe day. And I request everyone to be on mute other than the speakers, both audio and video, and other than the panelists probably. Thank you.
Thank you so much, Saraswati Madam, and good morning to everybody, and warm welcome to the panelists and the attendees on a wonderful Saturday. I think we have chosen a right topic, and thanks to Mr. Vaidishwaran, who's our internal Wikipedia on the resources when it comes to it. His article triggered the entire thought process of it, and there can't be a better time than today, because the headline today says government fumes as Twitter labels the toolkit post as manipulated. That is the heading today, which is going to trigger further controversies on several things on this. So this intermediary guideline and digital media ethical code has been introduced in February of this year, which is the most, I would say, the required regulatory and ethical code which every country, every society is contemplating on. So having they have said that today the scenario is that the days have gone where the government kind of rules and influences the society. It is the media and the intermediaries is influencing the people. they have the complete platform and the wherewithal to influence across the cross-border and go reach it to the people. And the corporates are becoming stronger and stronger in making their presence felt in that particular area. So every country is looking at regulating that, and that is what the Indian government has also done in terms of regulating and bringing this ethical code. We all seen what happened in a White House with the one single tweet from the ex-president, and what the kind of a catastrophe they went through. By the time they could react, the damage is done. So now on the other side, which is there is an essential thing, and at this point in time, it is left to the individual corporate to decide what is right, what is wrong, and what they are supposed to be doing. And it has been getting no thing, and there is no stronger rules or regulations. Maybe they are in a different part of the law, which we are going to get enlightened by the stalwarts sitting here. So, but on the other side, there is no stronger proof or a thing to go and get hold of any of these people, because they operate both within the country and outside the country, and the digital footprints lie inside the country and outside the country. Every coin has two sides. On the other side, such codes and laws and rules, what is it going to be doing in a good ethical business practice? How is the laws going to get interpreted in terms of holding on to a company which is just not only the social media, but also intermediary, meaning any company which is into providing a services to people, could be as simple as website hosting, where they are providing the platform for other people to come and host the data. Is it practically possible for companies like GoDaddy which is publishing maybe millions of websites, to go through, scroll through the contents to say what is right, what is wrong, and they will be held responsible by the respective government, or in Indian construct, India will be holding them responsible for doing such things. Other question on the other side of the coin is it intruding into the privacy of somebody putting the data? Is it getting into the fundamentals, rights of a speech and expression of our ideas? So these are all the questions which triggering one rule and every law as always comes to the debates and discussions, and it goes through the maturity over a period of time. And here we are in the law, which is getting which is coming into the practice to try and get some of the answers. And we've got there can't be any better people than what we have as a panelist, headed by the moderator, Mr. Vaideshwaran, and Savita would be introducing the panelist. I think I am equally excited as each one of you to listen to find out how this is going to be practically possible to implement in countries like India, when the basic other fundamental things have not still put in place, things like GDPR and other things. So this we will leave it to the panelists to enlighten all of us, to take us through to understand what is the industry perspective, what is the legal perspective, and at the end of it, I'm sure that we are going to be more enlightened about this. With that, without wasting further time, I would invite Savita to come and introduce the panelist, and then we can start the discussion. Thank you so much, and stay back and let us get enlightened.
Thank you so much, sir. So without much ado, let me just introduce our esteemed panel for today. First and foremost, I'd like to introduce Ms. N.S. Napane, who's a Supreme Court advocate and the founder of CyberSati. She's a senior renowned lawyer focusing on litigation and policy work, but she also takes on a lot of social responsibility engagements, such as on the training aspects with respect to the judges, police, the armed forces, and industry. She appears as a counsel in cases pertaining to constitutional law, criminal law, IPR, and cyber laws. Her main expertise has essentially been in criminal and constitutional cases, and she has handled also financial fraud cases as well as white-collar offenses. She was part of the government committee formed in the above matters and lent her expertise essentially in formulating proposals in these aspects, and has represented several cases with respect to constitutional issues also at the Supreme. Supreme Court. Ms. Napinay is an advisor for the Maharashtra Cyber Police. She's a senior panel advocate for the Central and Western Railways. She also has presented before the Lok Sabha Parliamentary Committee on Women Empowerment on Cyber Safety Online, and she has presented before the National Cyber Security Center, part of the Prime Minister's Office on India's proposed National Cyber Security Policy. So I welcome you, ma'am. Mr. Pranesh Prakash, who's our next speaker, is essentially part of the founding team of the Center for Internet and Society, a National Law School alumnus. He has essentially considered to be a default reference point with respect to a lot of matters on law and policy related to Internet in India, including copyright, freedom of expression and privacy. And that is also the genesis and basis for the Center for Internet and Society. It was in recognition of this work that he was selected as the Internet Freedom Fellow in 2012 by the US State Department and was appointed by the Indian government to a group of experts on privacy under Justice A.P. Shah. He works with several delegations from multiple southern countries at the World Intellectual Property Organization and also participates actively at the Internet Governance Forum. Welcome, Pranesh, as part of our panel. And last but not least, we have Mr. Rajendra Dandapani, who's the business solution evangelist of Zoho Corporation, who's been in the news quite often. He's a graduate of the IIT Madras as an engineer in electronics and electrical communication. He has spent over 7 years at Zerago, which is Asia's largest new age marketing entity, basically picking up the team, managing the projects, servicing clients, including Citibank and SIFI. Post joining Zoho Corporation in 2004, he launched Jambav, a portal for dozens of tools for games for parents and children, with special focus on children with special needs like dyslexia, Asperger's, and autism. Toondu from Jambav arguably is supposed to be the fastest way to create and share comic strips online. And also he is a leading mobile first mindset. He has conceived apps and services that echo a strongly held conviction about big data plus small apps. He manages and guides a team of about 75 developers, artists, and visual designers spearheading Zoho to the forefront of the mobile revolution. Welcome, Mr. Dandapani. And putting them all together and bringing them together is a moderator for today, which is Mr. K. Vaidishwaran, the advocate and tax consultant in Chennai. He has over 30 years of experience in handling matters related to taxation. He has appeared before appellate authorities, tribunals, and courts, both in corporate law and tax matters. Apart from that, he has authored several books on VAT, SENVAT, and indirect taxes, and is a faculty in indirect tax, GST, in many institutions. His latest book is The Taxation of Digital Economy, available in Amazon. Apart from a law degree, he also holds additional qualifications from the Institute of Cost and Works Accountants and Institute of Company Secretaries of India. He is a general committee member of the Chamber and also the chairman of the Chamber's GST committee. So I welcome you all on board. What is interesting, I think, with the panel is each one comes with their niche expertise as far as the particular area is concerned. And I think that is going to make this a tremendous panel. So thank you so much. And I hand over the mic to you, Mr. Vaidis.
Thank you, Savita. Thank you, Ashok. And good morning, dear friends. And a very hearty welcome to Napinay, Pranesh, and Mr. Rajendran. Just to set a context on a lighter note without going to the technical aspects, because we have a distinguished panel who will take us through that. Typically, the life today is we wake up in the morning. The first thing we look at is our phone. Most of us, let's say most of us, because there are some good exceptions, open up WhatsApp immediately and we read stuff. And not only do we read stuff, we take it down as a duty to pass it on to the rest of the world. And despite WhatsApp trying its level best to limit to 5 forwarding segments, we continue to patiently forward as much as possible. And what we forward could be news, what we forward could be information, what we forward could be something which we read, we think as true, which is patently false, or what we forward with a bit of glee is what we read as false, but could be patently true. There is so much of misinformation, information, disinformation. This is just one example of a social media. But all of us do this, and all of us do share all this stuff. And it's a kind of a Maya world where today nobody is able to decipher or have the patience to find out whether it is authentic or not. In fact, given the topic that is relevant to us, you will still see news item about 66A getting struck down by the Supreme Court on a daily basis. You know, the Supreme Court did years ago, but that will come as a hot news today. And there'll be a set of fellows who will forward that thinking that something new has happened. So this is quite common, dated news, new news items and information that keeps coming. And then you have the menace of fake accounts, which you can't, whether it's a verified account or an unverified account, or how much can you do? What are you expected to do? This I'm talking about a pure citizen perspective, when he picks up the phone and looks at his Facebook content or Insta content or WhatsApp content or anything else. And then we have digital news. And you also have a writ petition being filed questioning the new rules, which is a subject matter of a discussion. So this is one side. The other side is you also have a new form of abject violence being depicted in web content. And this violence is something beyond what we normally see in some of the English web series. The regional content has given a solid beating, so to say, to the English content in terms of either raw violence or raw sex or anything which would probably make you shudder to watch. So with this background, what did the government do? Or what did the government think they could do? The government thought that they need to have a say on this. They, how a government, normally how regulation works as a lawyer is that they think that by law you can control everything. Law doesn't work that way. But then they've made an attempt. So in that background, they've created these new rules. And as Savita and Ashok rightly put, we have a fantastic panel because we have somebody from policy, somebody who's an expert in law and specifically in cyber law, and somebody who's from the industry. And I take immense pleasure to address my first question to Napinai, who is also my friend from law college. We did law together. So it's so nice to see her as part of this panel, and it was nice to see her resume too, though I knew what all she's done. So Napinai, the first question is to you. From an audience perspective, who may not have gone into the rules in depth, or from a non-lawyer's perspective, can you explain the scope and ambit of these new provisions?
Yes. Thank you so much for having me here to the Madras Chamber and to you, Vaitishwaran. It's a pleasure, of course, to be here on the panel along with you. Well, if I were to walk you through the entire intermediary guidelines, I might as well take the whole day. So without doing so, I'm just going to give a quick overview. As I always say, it's always good, as the song goes also, to start at the beginning. Because sometimes as time goes, we tend to forget the basics. And by doing that, even in the process of policy making, probably the lawmakers also tend to forget the basics and go beyond the parameters of the law, the parent law, or as it is meant to function. When we talk about intermediaries, today all of us are a lot more conversant with the implications of it. So we know, and when I say we, I mean as laypersons, right? All of us know that a social media platform, a chat app, amongst others, are intermediaries. So what exactly was this intermediary guidelines meant to address? And where does it get its teeth from, or how is it permissible for rulemaking, right? The primary provision from the Information Technology Act, and keeping in mind, Vaitishwaran, that I'm addressing your question, I'm going to clarify that in this session, whenever I say IT Act, I mean Information Technology Act and not Income Tax Act, right? So in the IT Act, you have a provision giving an exemption to intermediaries from liability for content that is being carried not created by the intermediary, not curated by them, but carried by them on their platforms. And the whole idea of the exemption is that if I'm just providing a platform for third parties to come and put their content there or allow it to be transmitted, and there may be a storage process in it, then I, as a person who had no control over that content, should not be held liable. So this is broadly the exemption that is envisaged under Section 79 of the IT Act. And under that provision, there is a catch that you will get this protection. It's called a safe harbor. So you will get this protection provided you do XYZ. And XYZ includes exercising due diligence and following the guidelines laid down by the central government of India. And that is the teeth with which the intermediary guidelines has come in, or is supposed to have come in, along with the enabling provision for creating rules under these substantive provisions. So when you look at this background, and like I told you, I'm starting at the basics, and I will very quickly finish up in terms of what the guidelines have brought to us. It is split into three parts. The first part is the definition part. The second part is what is relevant with respect to Section 79 or intermediaries, as we just spoke about. And it brought in two very distinct and important aspects. There were intermediary guidelines even prior to the intermediary guidelines of 2021. The 2021 guidelines are not the first of its kind. It was just a modification or amendment of the existing guidelines. In part 2, it captures substantively what was there in the previous guidelines. One of the provisions under the old guidelines, which was struck down in the same thing which you mentioned, the Shreya Singhal case, which struck down 66A, also struck down takedown of content through user notice. But it retained or affirmed the validity of takedowns through government notices or court orders. Now, these two aspects are recaptured in the new guidelines, and the timeline remains the same of 36 hours. And it also creates a separate category of significant social media intermediaries. And a separate notice was issued delineating that 50 lakh users would be the significant social media intermediary category, and additional provisions are set out for them. Two things which are very important for users is there is one provision for takedown, which is a carryover from the old guidelines, which is for through government order or court orders within 36 hours. But, and this is a big but, and it's a very important one, we have seen consistently a lot of problems with respect to what is colloquially referred to as revenge porn, but which I prefer to just call cyber extortion. This is the uploading of private or personal content without the consent of the data subject online for the purpose of either threatening or shaming or causing harm to the victim. So these kind of cases have been predominant for a long time, not just during COVID, and more so now also. The other thing, which in fact, that is the one for which I'm appearing as amicus curiae before the Supreme Court, is the horrific problem of actual rape and gang rape videos being uploaded online. And in Prajwala, it was also expanded to include the scope of child sexual abuse content being uploaded online. So when it comes to content like this, any kind of content which is abusive of a victim and which discloses the private areas of the victim, if a complaint comes from the user, then within 24 hours, that data has to be taken down. Now, this is an important thing, and that's why I emphasized what was struck down in Shreya Singhal, because in Shreya Singhal, what was struck down was an open-ended provision which said that within 36 hours of a notice from a user also, you needed to take down content. Whilst that was struck down for its open-endedness, Now a new provision is introduced even where a user notice can result in a takedown, but for a very specific category of content which will be uploaded online. The second most important thing is that intermediaries have to now have a nodal officer who's answerable and within the country's jurisdiction. And for significant social media intermediaries, there is also, apart from the grievance officer, there is a chief compliance officer who's also needed. So this is part two. The contentious issue, which I'm 100% sure Pranesh will be addressing quite a bit on, is part three, which deals with the media code. Now, the reason why I went down to basics was to emphasize what can be the parameter of an intermediary guidelines. And the crux of that is the inability of exercising control over the content on their platform. When you look at part three, the two categories which are captured there are both categories which have absolute control over the content which is on their platform. One is, of course, news media and curated content, right? So the very categorization itself takes it outside the purview of an intermediary. The second issue is that you're bringing in something which was not meant to be, is not covered in a parent law and through regulatory mechanism. And by doing so, effectively, the executive has taken over the role of a lawmaker rather than just the law implementer. So their only permissibility is to implement a law and to put down processes for such implementation and not create law. So part three in its entirety, according to me, would be definitely not sustainable. And that is something that is still pending to be reviewed by courts. Now, finally, one aspect in terms of the intermediary guidelines, which has also invoked a lot of contentious arguments, is the addition for the significant social media intermediary to introduce, and this is almost like a quasi-voluntary or a self-regulatory mechanism, introduce automated tools to find, identify, and take down expeditiously content such as what I just mentioned, which is child sexual abuse content, or rape or gang rape videos, or videos which are affecting the privacy of individuals. So it's a very precise and specific parameter laid down for the automated tools. The reason I'm mentioning this is actually again an outcome from Prajwala. A lot of things have come from the Prajwala case and orders that were passed therein. So effectively, all these were already part of law because the Supreme Court then passed interim orders based on consensus proposals. So two of the consensus proposals was for developing the research with respect to such automated tools. But now through the intermediary guidelines, it's become the law in terms of implementation. The second part, which is to also issue a warning for this kind of content at the time of upload through an automated process, was part of one of the suggestions in the committee under Prajwala, which was not accepted, but has become law now under the intermediary guidelines. I thought these were all important, particularly from the construct of online safety. Yes, there are certain risks and concerns with respect to how it may impact free speech or free expression online. And that I'm sure we'll address going forward, but I will pause here for the moment. Over to you, Vaiti.
Yeah, thanks, Napina. That's a fairly important point that you raised, that the key objective behind these rules is to ensure, or at least attempt to ensure, prevention of this horrible crime that keeps happening in social media, where women and children are victims. There is abuse, there is threat, there is soft content and body shaming, and so much that is happening. And definitely in that sense, the government rightly has intervened, I would say. But I would like to go to Pranesh on that. Before I go to Pranesh, I would like just to, for the benefit of the audience, read the element of the rules, which says that the intermediary, through rules and regulations, privacy policy, or user agreement, shall inform the user not to host, display, upload, modify, publish, transmit, store, update, or share any information that belongs to another person. Then whatever Napinai said, I'm not expressing them again. Defamatory matter. Apart from that, gender-based, libellous, racially or ethnically objectionable, relating or encouraging money laundering or gambling, or otherwise inconsistent with or contrary to the laws of India, infringes any IPR, violates any law of the time being in force, deceives or misleads the addressee about the origin of the message, or knowingly or intentionally communicates any information which is patently false or misleading in nature, but may reasonably be perceived as a fact, impersonates another person's, threatens unity, integrity, defense, security, and sovereignty of India. At least the last part, unity, integrity, defense, security, sovereignty, flows from the Constitution as well as Section 69A. But rest of them, in the garb of rules, seem to have gone overboard. Pranesh, your thoughts?
I agree. So, as Napinai said, these actually aren't new. There have been some slight modifications to what you read out, but these actually were there from 2011. And when I was a part of the Center for Internet and Society, we raised hell over it then as well. Because if you actually search for how this disparate set of things came together in this rule, you'd see that these are actually standard terms that are available, say, in the terms of service for the World of Warcraft or for Yahoo. Okay, and they've just copy pasted from the World of Warcraft's terms of service into actual subordinate legislation. So it's kind of odd for the government to insist that all intermediaries, okay, and this is applicable to all intermediaries, including, for instance, I have a private email server, prakash.im, which I provide, through which I, in essence, provide services for my parents as well. So I thus become an intermediary as well, because there is no limit, and minimum limit set in terms of how many users you must have, or how many people's transmission of information you should be facilitating, and so on. So I am technically in violation of the law by not displaying these as terms of service on my to my parents when they're accessing the mail server that I've created for them. And we actually did an experiment as to how widely these kinds of things like harmful to a child, right? It's there in the sub-rule. So how widely would things like this be construed? We, in 2011, sent out variously defective or wrong takedown notices to intermediaries. For testing harmful to a child, we argued that diapers can cause baby rashes, and baby rashes are obviously harmful to children, and so an advertisement for diapers shouldn't be allowed on an e-commerce website. And we made these kinds of ridiculous claims. And what we found was that in the majority of the cases, where both substantively there were ludicrous claims or procedurally there were faulty claims, intermediaries erred on the side of caution and removed material. Now, as Napinai has pointed out, there still are a few provisions for which intermediaries are required to take down information if there's prima facie evidence in their eyes. Now, there are provisions such as that transmission should not contain any software viruses. Now, if I'm a virus researcher, okay, then I am soliciting people to send me viruses, and I'll be sharing these viruses via intermediaries, okay, with other researchers. Now, that is something that I am to be prohibited from doing. And this makes sense in the context of Yahoo. Okay, it makes sense in the context of World of Warcraft, maybe. It does not make sense as something to be imposed on all intermediaries, regardless of what kind of intermediary they are. Gambling, for instance, right? And now in certain states in India, gambling is legal. Advertisements for gambling is legal. Yet through the subordinate legislation, all intermediaries are to prohibit their users from promoting gambling in any way. I could go on, example by example for why each and every one of those kinds of conditions is wrong. But suffice it to say that this is beyond the powers that have been laid down, in my opinion, for the central government. This is, in effect, legislating and not within the scope of Section 79 of the IT Act. Apart from, so I think I addressed the immediate question that you raised?
Yeah, you did cover it adequately. And that's a fair point to say that it has gone beyond the powers conferred. And if you look at the judgment of the Supreme Court, when it made a distinction as to why one section was struck down and one section was upheld, the Supreme Court gave the logic that there were adequate safeguards and it was just not possible to just like that invoke this provision, and there was a mechanism that was set out as Napina talked about safe harbor and things like that. But whether these rules whether these rules can be justified under the powers conferred under that section is a moot point by itself, because how much of delegated power is there in the context of procedure, and how procedure becomes substantive can always become a matter of debate before the court. Now, coming to Mr. Rajendran, as Ashok rightly put it in the opening remarks, we are looking at multiple companies which are getting into this system. I don't know why there's an echo. Saraswati, can you check it out?
Yeah.
This WebEx has got its own challenges, as she rightly said. Anyway, coming to Rajendran sir, see, Napina is a lawyer. I'm a lawyer. Ashok is a tech guy. Savita is a lawyer. Pranesh is lawyer, obviously. So we tend to look at it legally. We tend to look at it, pick and choose and discuss provisions which we like or which we don't like. But you have to live in the environment. You have to run your business. You still have to comply with these regulations. You can't afford to say these are wrong, I will not follow. So how does not only Zoho, how does the industry as a whole perceive these new rules? Your thoughts?
When I unmute, you seem to be having trouble in the audio, or are you okay? You're able to hear me?
I can hear you.
Okay, thanks. So as was very clearly made evident in the introductions, I am the outsider here. I am the joker in the pack. The number of legal terms that I have heard in the past 20 minutes, I haven't heard them in probably 10 years. So, but I would like to give you my outsider's perspective, but rather the tech insider's perspective of how, in plain speak, when somebody who is in the business and also is personally pretty active in social media, how would this impact the individual as well as an organization which builds software that lives on the cloud? So I just noted down some points and I would like to randomly touch upon them. The first thing is this number 50 lakh that differentiates the intermediary and the significant social intermediary. It is patently wrong to identify if somebody is powerful or not by just numbers. It might work with election campaigns, but that is not the way things work in today's social media. The classic case of the counter example is the app called Clubhouse. I'm not sure how many members here have used it. I went in and came out very soon. I haven't used it much. It is an iPhone only app which promoted the ability to have a virtual coffee table conversation with Elon Musk will come and let his hair down and have a freewheeling conversation with you. It was it was boasted around. It was promoted as an exclusive club that to even enter it, you need to have an iPhone. That automatically discouraged 1 billion people in the planet. And that was its claim. So influence is not the normal distribution where some people have much influence, some people have very little influence. Most of the others are in the medium. It is a power law. Everybody has no influence. A very few people have some influence, and countably small number have disproportionately huge influence. So the Clubhouse will probably never reach 50 lakh subscribers. Its business model is to not reach it, but we will be amiss, far from actually doing the real thing if we are going to let Clubhouse slip away. I just used Clubhouse as an example to identify, to underline the concept of exclusivity being the business model itself, the club exclusivity. And that was completely lost in the document that I saw. The second thing I really was looking for but missed out was the angle of vernacular content. India specifically is not an English country, and there are so many languages. And I was looking for some mention, some approach that acknowledged that diversity. I couldn't see that. You talked about 24 hours, 36 hours, take down notice and all that. But when you look at the internet, the velocity of content, the number of jumps, I remember even today when in 2007, 2008, the last book of the Harry Potter series was pirated and leaked by some character living in some remote godown. He had slipped the book out, taken photographs, and published it online. The great strength of Cambridge and J.K. Rowling could not trace the documents and could not identify all copies of it and destroy them. That still, even today, you can search for it, and a photographic version of the last book of the Harry Potter series is available out there in the dark web. The whole idea of tracing the origin sounded ridiculous. Are they even knowing what they're talking about? Is the feeling I got when I was going through the document. And about country and storage and governments sending out a warrant to extract information or take down information. I don't know if they had given enough importance to the fact that geography is now history. Yeah. So most such organizations are multinational. They have their data center somewhere. They have their users somewhere else. They have their headquarter in some other country. It is a pretty it's not a pretty hairball, and I wanted some explanation and some acknowledgement given to those practical logistic problems. WhatsApp, I don't know if you all remember the story of WhatsApp's origin. It was born when the creator, the founder of WhatsApp, was having breakfast at the table, and he heard his mom typing on chat to a neighbor in the other street. And suddenly she called her and said, "Hey, wait, I'll come on phone now. I don't want to type on chat what I'm typing." Because they were concerned that the Russian media or the KGB probably were watching every letter that was typed. That was why it was born. And WhatsApp made it very clear that we don't even store the information. The moment you see those two blue ticks, we have deleted any content that is stored in our servers. So I was wondering, there is storage, then there is encrypted storage, then there is strong enough encryption that prevents even the owner of the storage, the storage to decrypt it even if needed by law. And then there is vanishing storage. Did the document even acknowledge the presence of those things? I couldn't see those in the document. And overall, my feeling is, yes, we need some kind of legislation, some kind of control. It's already Wild West out there. There is a land grab happening. But I am optimistic, but guarded optimism is how I would put it. I want to wait and watch. This government and many other governments, not just in India, even internationally, have proven that they are always slightly behind the private enterprise in terms of foresight and in terms of innovation. So it's been knee-jerk, post-mortem, retrograde. So I'll have to be guarded about that. I understand that in this competitive landscape, it's very easy for a document to come out like this, which can shackle the small companies and be biased towards the large ones. That can happen. And it shouldn't also end up penalizing the very large ones, because they also have some of the biggest concerns large companies have is about this little startup in a garage that's coming up with a world beating algorithm that's going to render their product meaningless. So we'll have to be careful not to choke innovation both in the small and in the large organizations. Overall, I feel self-policing and crowd-based policing, crowdsourced policing problem a lot more than having one central authority that will rule with an iron hand. Those are my tech insider, law outsider opinions. Thank you.
Fair enough. Thanks, Rajendran. You did set a note. Of course, I'll go straight to Pranesh, and two questions to Pranesh on this. One, do you have a differing point of view on the storage aspect that Mr. Rajendran talked about? And two, these are clearly self-regulations, which at least initially they are self-regulations, and failure to them would invite the wrath of the government. But in the context of self-regulation, assuming something inappropriate has been posted, let's forget the obscene element for the moment. Let's say that there is a complaint, and the complaint has come from a vast set of, there's a mechanism for complaint and grievance, etc. So there's a complaint has come from a vast set of vast hordes of followers of a particular individual, and based on the complaint, the intermediary decides that the content should be deleted, and it removes content, or it asks the user to remove the content. Now, assuming a deletion happens, is that enough? Because this, as Rajendran talked about, how J.K. Rowling struggled in, of course, she did have her victories in some other matters, but how did it struggle as far as this violation of copyright is concerned? There could be any number of sources by which the same information would have traveled across multiple intermediaries and multiple platforms, need not be through the same user. And there are even today people take screenshots of one database and share it through another social platform. So, and that gets circulated to the other platform. And now with people having their, 1 feet in this side and 1 feet other side, they are part of WhatsApp as well as Telegram, because they're not too sure whether WhatsApp will go away or not in terms of their friendly group. And therefore they're posting in both groups. So if content is going to get circulated through different mechanisms, how effective do you think even this deletion works? And your thoughts on the storage aspect, Pranesh?
Just want to clarify, I don't quite disagree with what Rajendran said on storage. I just found the story about WhatsApp's founding amusing. It's probably apocryphal, given that WhatsApp, when it started in 2009, could actually read all your messages. It didn't get into an encryption until 2016, after Facebook took it over. So, and I remember in the initial days, WhatsApp was possibly one of the worst in terms of security. You could impersonate another user with faking their phone number and so on. Even there were multiple vulnerabilities in terms of even being able to read other people's messages. So it was terrible from that perspective. But I digress. On storage issues, I actually agree with Ranjendran. So into the going, I'm sorry, I keep going back to 2011, but I was far more active on these issues then. But then itself, we pointed out to the government in our comments that you need that intermediary regulations and guidelines of the sort can't treat all intermediaries alike. There are different intermediaries that perform different roles, and they should have to abide by different rules. So those that store content and our platforms are in a very different position from those that merely enable the transmission of content, such as ISPs. And those are in a very different position, say, from newspapers, which have a comments section and thus become intermediaries. So, and those are very different from e-commerce websites. So each of these are very different in how they, what kind of responsibility they ought to bear. And that recognition, which part of which is due to whether they store or not, but not exclusively on that, is completely missing from these guidelines, was completely missing in 2011 and continues to be missing even today. So it's rather disheartening that criticisms, which I think are pointed and valid from 2011, still have not been accounted for 10 years later. The other point, I'm not quite sure if I understood the question correctly, but I think I choose to interpret it as a question about the first originator provision and being able to trace first originators even on platforms that are end-to-end encrypted. Now, that to me raises concerns about not just privacy, but what we should be asking of intermediaries. Should we actually force them to revise their entire architecture? Say if they're end-to-end encrypted and they aren't technically in a position to know who sent a particular message first, as opposed to later, should we actually force them to change that technical architecture to be able to do such tracing? That to me is not an easy question to answer, and at the very least, it's not clear that there's a overwhelming need to say to figure out who the first originator was in every case. For instance, if people are engaging in piracy, which for people who may know me would know that in most cases I actually support piracy. But people who, even those who don't, would agree that every new instance of piracy gives rise to a new offense, right? So if I'm engaging in piracy, then it's not only the first person who put it online who really is doing the wrong of copyright infringement, but I am as well by spreading it along. Similarly, if there's say child sexual abuse, and if I'm passing it on, it's not only the creator of the child sexual abuse material, but it's also the person who's passing it along who should be prosecuted. And it's not always possible to trace creators. And if you look into the work of folks like Europol, who do excellent work, on child sexual abuse material and bringing perpetrators to justice, you'd see that they don't usually they're not using metadata like IP addresses to do the tracing. They're using things such as what's available in the video itself to figure out where in the world it was actually shot and to go after the perpetrators. So talking to people who actually engage in tackling crime of this sort would have helped, rather than assuming that it's done through a particular kind of mean, and assuming that technical means actually help get you to the first originator, as it were. So for me, this obsession with first originator is a bit of a red herring. To give another example, which I've written about, if there are people who read messages that are meant to inflame, and then they go out and they beat up people or kill people on the basis of those messages, then it's not the first originator of that message that I'm really bothered about. It's the last originator of that message, and that information is available. And it's the people who are actually committing the violence that I'm bothered about, and that information is available with the police. So for me, it's not always clear that I always need to be looking for the first originator, or police to be able to do their job need to be looking for the first originator as opposed to an originator or the last originator of a particular message. And so I hope that answers both your questions. One on storage, I think the storage aspect is very important, and there should be, and we actually in 2011 we proposed, we had a counter proposal from CIS, which we looked at different models of governance across the world, and we said, okay, if we have to treat these intermediaries differently, how do we do that in a manner that both makes sense and is compliant with Section 79 of the IT Act, and what powers it actually gives the government, and so on. And so we so for anyone interested, you could actually look up the counter proposal, as we called it, on Section 79 rules that CI has put out in 2011, where we actually drew these distinctions and said and provided a practical option for how to treat different intermediaries differently.
Yeah, thanks, Pranesh. And with the example that you gave in the context of an inflammatory post, where there is an originator and somebody keeps on sharing, and somebody takes action based on that inflammatory speech or inflammatory post and causes damage or arson or whatever. There are enough stories in the past to show that these things do happen. Though how much are believable or not is another question, because we still don't know whether the one that gets reported is true or not. But building on that question, I move on to Napinai. Now, assuming such a scenario takes place, there is inflammatory speech or content. There is a first originator, and then it has moved on. And as I said, somebody has shifted platforms. It is now available in other platforms too. Other intermediaries have also shared this information, or in some other format, it has circulated through other intermediaries. And this is somewhat akin to what the country is currently doing or did in the last year, when for COVID, government tried to do a tracing of contact. They tried to look at where all this person went, what was his immediate circle, what is the next circle, and in the whole process, we discovered that was not very effective. And while we did find out, to a large extent, we did miss out. And we also found out that people were lying. So the addresses were false, the information was not correct, and they confined themselves to their homes when they came out of the airport and went out shopping to Pondicherry the next day. So these things did happen. So if in the physical world these things happen, these will be magnified in the digital world, and these kind of false IDs will be even more significant. So with your experience in cybercrime and also being part of the advisory panel for the Maharashtra Cyber Cell, with the example which Pranesh pointed out, which I've elaborated, who would you pin responsibility and liability on, as well as what would you think would be the role of the intermediary? And do you really think that government can hold anybody responsible so quickly before the damage is done?
I would actually address it from the perspective of Napane as a policymaker here, more than as a lawyer or as a practitioner, you know. See, the whole first originator construct itself is actually missing the primary issue here. Everybody assumes that when we speak about the intermediary guidelines, it's only the media code that is a problem in terms of exceeding the mandate, and that everything about part 2 is fine. And the reason why I said I'll address it more as a policymaker is how the policymaker thinks. It really intrigues me, you know. So if a Shreya single judgment says that takedowns are permissible when it is through a judicial order or a government notice, the assumption that the policymaker draws from it is that as long as we stick to the judgment in terms of, you know, it's so such simplistic thought. Freedom of speech, as long as I put all the wording in Article 19.2, I can violate it. Okay? If it is rights in terms of what is permissible and not permissible for law enforcement to ask, Shreya Singhal Supreme Court judgment said, oh, judicial order or government notice is fine, so I will follow that. That is not what the Supreme Court said, nor is Article 19.2 a permissibility, you know, a catch-all net for you to take away freedoms, right? So that's where the problem really lies. So if you look at the wording in terms of first originator, according to me, the very provision itself is violative of the Parent Act. And that is something nobody is really talking about, you know, and that's something they need to address. It's violative of the Parent Act because the Parent Act does not give leeway to the executive to form these rules, according to me. The second aspect is, assuming it is there also, how far are the rules enforceable? Let's not get into the first part because the assumption will be that any judicial order will go into the legality or the fundamental rights aspect. The second part is what I'm very concerned with, because here is a situation where a rule is formed. So delegated legislation is already done. And for that delegated legislation to be implemented, you need further rules to be formulated because otherwise it won't work. And why am I saying it? Because the first originator rule allows the law enforcement officer or a government agency to issue notice and seek an order under 69. 69 is for decrypting, monitoring, etc. Now you already have provisions and rules under 69 which don't go into a first originator aspect. So you're bringing in a new angle absolutely to 69 and claiming a right under that for a law enforcement officer or a government agency to seek information. And what is the parameter under which they can seek the information? When can they seek it? How should they do it is not addressed in these intermediary guidelines. So for you to implement a provision of a guideline, you need further guidelines. That is not permissible, and where this clarity is not there, like I said, even assuming that you're not going into the first aspect of it, on the second ground of ambiguity, this part will necessarily have to be struck down. And finally, can it even be asked for under 69? According to me, it cannot. I'm not going into the legal aspects of it right now, but the very short sum and substance of it, what I would say, 69 would not be the appropriate provision to ask for it. And if it is not 69, then what for a government agency, right? That is again open-ended. So the clarifications, a few additional inputs I wanted to give based on what Dandapani had shared was that when he was addressing about the originator rule, for some reason he jumped from the takedown provision to the originator rule, and I wanted to clarify to de-link it. The takedown provisions are very different from the originator rules. It has nothing to do with each other. So we should not confuse the issue with respect to the first originator rule, which is obviously disproportionate and excessive, as opposed to a takedown rule, which is necessary for balancing fundamental rights with the right of a corporate entity. The first originator rule, as Pranesh said, is not just about privacy. According to me, it's actually the ultimate thing which we have been repeatedly reiterating since Aadhaar, which is the chilling effect. So when exactly is a platform supposed to trace out the first originator? Is it after an order or continuously? If it is after an order, what is the technological capability of a platform to find it? And what is the harm that you're trying to take down, as opposed to the investment in terms of revising architecture, whatever. I don't agree with Pranesh on the architecture part, because if a law says it has to be done, too bad for the organization, it will have to be done. Of course, yes, there it is going to be a pain point, but that is not even a ground in terms of legal formulations for it to be taken into account. But yes, it is definitely going to be a pain point. But the real issue here is, if it is to be after the order, is it going to be possible for a platform, if they are otherwise going to be held liable for not complying with the requirement, and therefore they have to make sure that it is available, then it becomes a privacy issue, because then they are tracing everybody all the time. So for the ailment of a fake news or hate speech, do you want to reverse the construct on its head to make everybody a criminal unless proven otherwise, and keep tracking them? Or are you going to only allow for some form of surveillance or tracking mechanism after reasonable doubt is proven? The very basis of criminal jurisprudence is that you cannot start randomly in terms of, be it investigation or search and seizure or whatever, right? You need reasonable cause. So applying first principles, if reasonable cause is the basis on which you can start tracking or tracing, one has to assume it has to be subsequent to or not prior. It cannot be an ongoing process that a government can ask anybody to do, corporate or otherwise, right? So that is where the real weak link lies in terms of the first originator rule, amongst many others. According to me, it should be a no-brainer to strike it down, but we still have to wait for a judicial review on that process. And just if you would permit me for half a second more to clarify on some of the things that Dandapani raised, the vernacular content part, very important, and you may be interested to know that the Prajwala case actually dealt with it. So when we put out this warning ads in terms of somebody coming and looking for child sexual abuse content or rape and gang rape videos, we ensured that vernacular was covered substantially. In fact, the focus was more on vernacular than on English also. You also raised about enforcement issues, and WhatsApp, I think Pranesh has addressed it. Yes, I don't agree with the story also, because then the story is completely ignoring the fact that NSA was surveilling right at that time. Forget about Russia, etc. I think that's an overreach and an overkill, and forgetting what is happening in your own backyard and worrying about a spectre out there. And finally, about the 50 lakh thing. So I'm just going to take 1 second to address all this, to tell you that law doesn't work that way. It doesn't have to set out in terms of, oh, you have to do it in vernacular, not do it in vernacular, etc. Of course, something that would mandate an intermediary to put in some precautionary measures in terms of the vernacular that it is offering would be a clarificatory process. Nothing stops them from doing it, particularly if the platform is already offering something in vernacular. In fact, when the IT Act was passed in 2000, our complaint was that you are not clarifying, you're freezing technology, because of the use of the word digital. So the more specificity you're asking for, the more you're also freezing law at a particular point of time. So that's not necessarily how law works, and you don't have to assume it is not there merely because it's not specifically mentioned. And the last point in terms of the 50 lakh thing, it's actually taken from the Personal Data Protection Act. The bill carried already this suggestion for including it, The bill still hasn't seen the light of day, but the 50 lakh limit has. So we've already raised a lot of issues in terms of how do you delineate. But when you're talking about this, the argument that comes up is that we don't want to burden smaller businesses with more compliance, and therefore we are putting this in place. So now the catch situation that we are in is either we make it open-ended for all, because the kind of requirements that are needed from a significant social media player is not something that is so difficult for any social media platform to do. So either all have to bear the brunt of it, or some, to say that because this causes a difficulty for certain significant social media platforms may not necessarily apply. So the Clubhouse example that was given may at best make it disproportionate by allowing for a differentiator for some as opposed to the other, and therefore that rule to be made applicable to all. But to wish it away may not necessarily be possible today. Thanks, Vaidhi, over to you.
Yeah, that point is correct in the sense that thresholds are brought in for certain reasons, and we have seen enough instances where the lawmaker tries to their own way as who's big and who's small, and their justification for that is also upheld by the court in most cases. Moving on to Rajendran, I would like to draw our attention to one aspect of the rules pertain to significant social media intermediaries, where the rules mandate that such an entity should appoint a chief compliance officer to ensure compliance with the act. This guy would be liable for any proceedings under the act. It also requires a nodal person to be appointed to coordinate with law enforcement agencies 24/7, and also have a resident grievance officer. And the CCO must also be a resident in India and senior managerial person or senior employee. Now let's look at some of these big names here. You have Facebook, or you have any of those foreign companies which are operating outside the borders. And as you said, geography is history. For the purpose of these rules, these companies will have to appoint certain persons, and they have to maintain certain reports on all the complaints that have been received and resolved and things like that. I will first take your view from a corporate perspective in terms of how they see it. You sit in the shoes of foreign companies, you don't have to look at it from Zoho's perspective. And then I would shift this question to Nabina in terms of enforceability.
Yeah. So I'll make the mistakes and Napinai will correct me perhaps. Yeah, good order. So forget about Zoho. I'm not speaking for Zoho when I share my thoughts here. But in software, there is this phrase called Wizard of Oz prototyping. What they mean by that is, in the story of the Wizard of Oz, there seems to be this supreme oracle that is automated, that has the answer to everything. That's behind the screen, though it's actually a living human being. There's another term for it called the mechanical Turk. The first robotic chess player was a table with a guy hiding under the table making the moves. And people thought it was a robot playing the chess game. So when we get into something like this, yes, we will have to appoint all these roles. And we would, of course, being a software company, we would try to automate these processes. We will try to observe, we will try to, they call it hand coding or hand flow. Just have an army of people who will go through the process using human intellect and insight. But while doing that, keep a constant watch on which of these can be processified, which of these can be automated, which of these can be removed from human oversight. And that is when you bring in software workflows and probably eventually automate it so much so that only anomalies, only complete outliers pop up for human intervention. That is the only viable approach available, given the numbers we are talking about, number of billions of messages that are flying around, a video being particularly very hard content medium for us to actually find if something is. YouTube, for example, has a very good algorithm. If you introduce a copyrighted song or a copyrighted movie clip in the middle of your 1 hour video, it will flag it for content because it's got some good algorithms that can detect duration more than a 10-second clip. It will detect and flag it. It's not a human being, but it used to start as a human being, the Wizard of Oz protocol. The other thing is artificially intelligent algorithms, machine learning will someday play a very important role in this. When I say machine learning, it doesn't immediately make it uh, Big Brother is watching, surveillance nation kind of thing, because even just 2 days ago, Google was hosting its Google I/O, which is its annual developer conference, and they really quite justifiably filled with pride, they announced the next big leap in their AI system. They called it Lambda and they called it MOM. And the key point there is federated artificially intelligent programs. What they mean by that is once upon a time, the Apple iPhone was way behind in AI than the Android from Google, simply because the Android was almost promiscuous in its sharing of data. So when you open Google Maps, it shows you traffic information about where there is traffic jam, where there is an accident, which alternate routes to take, etc. Not because Google has satellites going around watching everything from way up, but simply because there are so many other people on the street having Android phones, which is telling the Google mothership about slowness or unusual bumps in the travel. So what Google has done very recently is they have launched a concept called federated learning, which is quite open source. Many other companies are going to start doing it because we are now paranoid about sharing our data, but we are greedy about AI helping us do our work, day-to-day work well. So federated learning is machine learning on the device. You don't actually share any data to the cloud for it to be processed in the central server. You download some intelligence from the cloud, you train that intelligence on your device, and leaving the data behind, you send that intelligence back to the cloud. That is federated learning. And I think these approaches and these technologies will come into the fore more and more often as expectations on oversight and regulation become important. Also, there was this thing about a law of gravity by Newton and laws of robotics by Isaac Asimov. For the layman hearing this, both are laws, right? But one of them is unbreakable. Law of gravity, whether you read it or not, whether you believe in it or not, whether Newton has even discovered that law or not, gravity worked that way. You couldn't defy gravity. But when Isaac Asimov proposed the laws of robotics, he said, with action or inaction, a robot should not harm a human being. A robot should take care of itself as long as it doesn't disobey the first law, and so on. There were 3 laws of robotics. But those laws are guidelines. They are not derived from some unbreakable scientific fact. And so, when you talk AI, you are not going to be able to control artificial intelligent approaches and such methodologies with laws. Simply because it can be done, it is going to be done. There are going to be labs around the world. There are going to be people under the radar doing all sorts of stuff. So it is important that we acknowledge that you cannot regulate this out. It's going to happen. But I'm happy to share with you that it doesn't really mean your data is going to be shared and it's going to become some kind of surveillance nation where Big Brother is watching every one of your moves. So to summarize, I would like to say that yes, we will have to appoint the teams, the people, the officers responsible. Reports have to be shared. It talked about something like sharing a report every 6 months. I would rather say a transparency report should be live, shared as and when an incident occurs. That is how it should be shared. And we would have to hand code it. We will have to do a Wizard of Oz to understand what the requirements are before automating it, because they say in our field, premature optimization is the root cause of all evil, they say. Because when you optimize something, you lose the ability to tweak it anymore. So that's something we will keep in mind. And AI is going to play a very important role, but no need to be afraid, because people have acknowledged the need for maintaining, upholding privacy while also benefiting from the immense processing power up there in the cloud. So, thank you.
Yeah, I'll stay with you, Rajendran, on because you made some significant points on surveillance and AI. I would like to take that a bit further for the benefit of the audience and probably then go on to Napinai and Pranesh on the views. First thing is, yes, you're right. The companies would use tools. They would use significant AI to ensure that the so-called offensive content is picked up. But then, who defines what is offensive content? The AI requires parameters. So, how do you prevent the creator bias? And today, given the social media kind of network, you find that a set of persons could be blocked, a set of persons who make similar kind of noises are not getting blocked. So, who takes that decision, and what happens if an account is blocked is purely based on the whims and fancies of the editorial board. So, how do you even morally look at these guidelines? Say, take the Disney, since you give so many examples of Harry Potter and Wizard of Oz. You find these Disney movies, and when you watch those movies, you watch them carefully. If you watch them the third or fourth time, you will see in some scenes there is a bias somewhere, something written which should not be there, or some picture which ought not to be there. So somebody has played around. So how do you control this? I mean, I know AI has to control this, but then how do you prevent the human being from playing whims and fancies here?
Yeah, so I'm going out on a limb answering this question, but I just finished reading a book called No Rules Rules. It might be anathema to even mention this in a law environment like this, but it is written by the CEO of Netflix, and he talks about how he has laid down a structure of sorts in his company in the past 20 years that they have been in business. They actually started as a video cassette rental, a postal video cassette rental company, and today they are streaming content worldwide. And he talks about how over time he has understood that you need to lead with context and not control. There is a difference. I understand in a government working with its subjects, this cannot really fly. But in small teams, in organizations, this is what is actually happening. The groundswell is to lead with context and not control. You talked about who decides. I'm saying everybody decides. It is a crowdsourced approach to deciding what's right and what's wrong. We're all adults here, so I think I can make a reference to it. In Netflix, there is a really endearing show, a teenagers show. I would recommend all teenagers to watch it. Interesting movie is some private parts of a girl studying in that school. Photographs of it have been leaked and it's running around. And one girl is really shamed because it is her photograph that's going around, and there is a school meeting. Everybody is called in, the principal is addressing, and the principal wants to find out who launched the originator, who started this, and they are trying to track it. And just when all seems lost, and just when everybody realizes that the principal is not being sensitive to the question, the student herself might be in the room, the principal is still going ahead, something very interesting happens. One random girl in the group stands up and says, it is me in that photograph. And that starts a movement. Another random girl somewhere else stands up and says, it is me in that photograph. And then every girl stands up and says, it is me, it is me, it is me. And that seems to change the whole narrative, that actually exonerates saves the person from shame, and shows that it is not one person you're trying to shame, but you're fighting a battle against a whole community of united people. So if we can have most online communities, Reddit, for example, YouTube, for example, Stack Overflow, for example, they do not have central authorities who decide what's right and what's wrong. It's based on a simple majority threshold value, beyond a point of which you have to be put into a cool off room. If you keep typing too often, there are websites that notice that you're typing too often and send you to a cool off room saying, take a break, come back and then type. There are sites where if you don't have a number of likes, or if you have too many down thumbs, they moderate you only then. Otherwise, you're free to talk. So I think you should come up with systems where in the US, there is this neighborhood watch. Police can't be everywhere, so they put a neighborhood watch. So law-abiding citizens with time to spare can actually take the additional role of being a pair of eyes and a pair of ears to find out something is going wrong or not, and to alert the authorities. So I think that would be a better way to do things, rather than look at social awareness in COVID, for example. Police simply cannot ensure that everybody is social distancing. It's a drive. It is an awareness. It is a context creation. If you can create the context, you don't need to control. Is my take on this. Thank you.
Napinai, on enforceability, and any comments to what Rajendran said?
Vaidhi, I could not hear your questions at all because it was echoing. So if you could just repeat in the context of enforcement.
See, the question is twofold. One is in the context of the rules mandating appointment of very senior professionals as residents to operate, to control and monitor the entire exercise, and to file the reports and to make them liable for all the action. One, the feasibility of this in the context of foreign companies who generally stay away from the jurisdiction in which they have their maximum activity, and they don't even have their data centers here. And you're talking about a resident being employed. So how enforceable is this is one question. And the second part of the question is that we are yet to implement the data protection law. We did see the personal data protection bill in 2019, which is somewhere stuck in the parliamentary committees. But that also had its issues in terms of exceptions. But we don't have the data protection law like what we have in Europe. Or how then would you balance the right of an individual, the right of a subscriber to post whatever he wants? In fact, on a lighter note, if he opens Facebook, even if he doesn't want to say anything, the first thing Facebook says is, what's on your mind? So it kind of tempts him and urges him to put something. And if you take today Google, I think the last few days you see ask anything is the word that is coming up in the table. So human beings, what they are, they would love to post. So how do you balance this in terms of as Rajendran said, that even though they would look at number of dislikes that can happen today, you can create number of dislikes. A Twitter post, you can have 1,000 fake Twitter accounts which will dislike that, and that will ensure that this post goes into a cooler room. So how would you respond to these things?
On your last point, it can even be a bot. You don't even need human beings to create fake likes or dislikes, etc., or for that matter, posts. So enforcement. There was a fallacy before this intermediary guidelines came in, that these are all predominantly foreign companies, and therefore you cannot enforce Indian laws on them. Even before the intermediary guidelines, my take has always been that you can enforce Indian laws definitely, irrespective of where a company is registered. Because the laws in terms of jurisdiction, in fact, in my book, one of the chapters deals with the issue of jurisdiction. I've called it jurisdiction in cyberspace, And I've covered every aspect of jurisdiction in it because I believe that was one point which has not been addressed in any book or publication till then, or for that matter, even today. The law is already decided, but it has been decided predominantly in civil cases, which is the test in terms of proximity, the long arm jurisdiction, right? On where it doesn't matter where a company is registered, if you are offering your services, if you're offering your platform except as a static platform. So for instance, a website which just gives information but doesn't offer any services to you, doesn't have any interaction with somebody in India, and has no personal connect with someone in India, except that someone in India may just access the website. That is what I mean when I say a static website. In those instances, yes, there may not be jurisdiction. But where you're offering your services, you are actively engaging with customers in India, you're already accessible to, or you're already amenable to the jurisdiction in India. So it is irrelevant where you are registered in. It's just that for social media platforms, they have to balance this enforcement from multiple jurisdictions. As far as the criminal provision is concerned, it's even more simple. It is irrespective, it doesn't matter who you are, as in an Indian citizen or a foreign citizen, it doesn't matter where you are. If what has happened impacts a computer or computer system in India, then you are subject to the jurisdiction of India under the IT Act. That is the extraterritorial jurisdiction that is built into the IT Act. You have extraterritorial provisions in IPC as well as CRPC also. Again, keeping in mind that this is not a hyper-technical legal aspect, I'm not going into all those. I'm only pointing out to the limited extent to show that you have the wherewithal. See, again, this was why I was pointing out at the cost of Rajendran believing I'm pinpointing something he said, but more only for the sake of you listeners knowing the right way forward. I'm pointing out that, yes, there are a lot of impediments in enforcement. We are dealing with a borderless crime or a borderless violation, civil or criminal. But you are also, your remedies lie in territorially bound laws. Now, that is a limitation we have to deal with because that is how laws work. But imagine the situation if the remedies were not there at all. So you're better off having remedies, good, bad, or ugly, rather than not having them at all. You're better off having difficult remedies instead of not having them at all. So yes, today you are relying on a dyadic or a two-way conversation rather than a multi-way conversation, because India has not signed into any international treaty, etc. That is something we really need to move forward on in terms of international enforcement. But till then, the dyadic, for whatever it is worth, still comes into play when necessary. So you have a letters rogatory option, you have an extradition option, depending on the laws in terms of each of the states and how it functions. And of course, your multilateral mutual legal assistance treaties, right? So this is where enforcement is. But for any foreign entity to believe that they are not amenable to Indian laws is completely misplaced. That part of it, for the sake of whatever reason, has been addressed further in the intermediary guidelines, but with the mandate for the grievance officer who is now in India and the chief compliance officer for the significant social media intermediary. So we've been talking about the WhatsApp issue where it's now trying to enforce its privacy policy. It's literally holding a Damocles sword and thinking that people will accept it, right? And you have the Twitter versus government issue that was briefly pointed out earlier in the discussion. In all of these, this has been my standard take and I stick by that, that they are offering their services in India, that they are interacting or giving on a platform where Indians can go and post and engage with. It is not a static platform. That in itself has given jurisdiction to India. So it does have, the Indian laws do have teeth. It is only a matter of difficulties or obstacles in its enforcement that we need to worry about, not the absence of laws or permissibility in enforcement.
Thanks, Napinai, but I wanted your view on the fact that we are still not having a data protection law. And what is your view on the fact that the subscribers are let it, they are kind of in the lurch? Is there data which you're talking
sorry, I missed the second part of your question on the Data Protection Act. Yes, many times, even for the Aadhaar issue and all that, when we were all vociferously arguing against the law, first the scheme and then the law, etc., we heard the law minister mention several times that these are bound to be there. Problems are bound to be there, and we will, as we go, as we learn, we will sort it out. For someone who took that kind of a view for Aadhaar, why is it that they are looking for perfection when it comes to the personal data protection law? I quite fairly don't understand. What are we waiting for? What level of perfection are we looking for? Ultimately, even today, we are going by existing precedents in terms of how we are framing the law, right? And why or what is the situation today? 2017, the Supreme Court has already affirmed that privacy, it affirmed. Again, people assume that we got our privacy as fundamental right in 2017. We didn't. We always had it. It was just a clarification and an affirmation that the Supreme Court gave. At that point of time, the need for India to have a data protection law was highlighted. And we are now nearly 4 years down the line. And I quite honestly don't know what kind of perfection they are waiting for. My take on it is this: you need to have your focus right. If a personal data protection law is intended to protect my personal data, please do that. If you're going to start treating a personal data protection law as a gateway to bring in other provisions which law enforcement needs, the government needs, XYZ needs, or the industry needs, or whatever, that is then taking away the focus, and that is where the confusion is happening. Every single argument, every single concern, including with respect to surveillance or otherwise, all of this is happening because of this focus going away, because the focus from personal data, protection of personal data has gone away. So today, the user has become again the least important actor in this main stage, which was meant for them, and everyone else has taken center stage. So that's where the delay is also coming from, because each stakeholder thinks their requirement is more important than that of the others. And the one primary stakeholder, the user, has no voice in all these discussions. So therefore, today we live on hope and a prayer that our personal data protection law will find its way finally with its good, bad, and ugly. And believe me, it is going to have all three of these provisions, and most certainly no perfection there. But we can at least say that we have something to start with. We can't keep delaying it. We need it. We should have it. If that had been in place, the issue we are facing today in terms of this WhatsApp Damocles sword would not have happened. If that had been in place, or the government thought fit to draw from the personal data protection draft on the significant social media intermediary, why did they not draw on this aspect about the privacy terms also and protect our users in the intermediary guidelines, which came well after the WhatsApp fracas, right? That could have been done. Again, focus is not there, therefore it's not done. So we can only hope, as I said, hope and a prayer that ultimately the fact that we are supposed to be the main actors, the individual, will at some point of time come to the fore.
Napina, I couldn't resist this. The user keeps talking about an important right, namely the right to be forgotten, whereas the user himself has been forgotten the whole exercise.
Fair point, absolutely.
Yeah. Moving on to Pranesh.
In fact, it's actually a right to erasure more than a right to be forgotten. So we have been erased, like that Arnold Schwarzenegger movie.
Yeah, 1 and 2. So moving on to Pranesh, you would have seen newspaper articles the last few days where a certain chief minister made certain comments about Singapore. And then there was a response in Singapore, and a particular legislation was also used in Singapore to kind of make the social media remove such posts. In your experience and in your wide knowledge of this subject, there are other countries like Singapore and others who have successfully implemented these kind of regulations, which kind of regulate these intermediaries through various forms, and how is the experiment? How far have they been successful?
So I think one thing.
Pranish, we lost your voice.
Or intermediaries, what should be allowed and what should not be allowed, and so on. What these are meant to be, I mean, it might seem as though they are, because that in effect is what they try to be, but what they're allowed to be are regulations on liability, as Napinai pointed out right at the beginning, in terms of saying when a third party, the intermediary, may be held liable for what you and I do using that intermediary, through that intermediary, right? So when should WhatsApp be held liable, or when should my ISP be held liable for what I do using that ISP, right? When should my domain name service provider be held liable, and so on. So that is really what these guidelines ought to be about. But instead, they are more in terms of general, regulation. Now, for general regulation, we already have the IT Act, right? For regulation in terms of, say, broadcasting imagery of private parts of people and so on, that is available in 66E, right? You don't need these regulations, you don't need these guidelines for having those kinds of laws. Okay, and frankly, the power to make these kinds of substantive provisions, in my opinion, have not really been provided under 79 either, because that power really belongs to Parliament and not to the executive. So that's one point I want to make. In terms of other global examples, of course, there are lots of examples. Any successful? I would say no. The only thing that is half successful in a way is a very, very heavy-handed GDPR. But there are examples. For instance, there's the Code of Conduct for Illegal Hate Speech that the EU adopted. In Germany, there are laws. In New Zealand, there are laws. Every country that has data protection law, which is more than 90 countries around the world, right? There are in effect laws regulating social media companies in some way or the other. So it's not, but the focus, the question we really ought to be asking ourselves is not whether they ought to be regulated and how and so on, but in what circumstances do we say, okay, it's not just the person who did the illegal broadcast and so on who is liable, but also the platform that is enabling that person should also be held liable. So that really, for me, is the policy question at the heart of this discussion. I'd like to quickly also bring up, address some of the issues that were brought up earlier. One, on enforcement, sure, you can have make any law extraterritorial if your constitution provides for it, but that doesn't mean that it's actually workable that way. Now we have had situations, and we continue to face situations where countries realize my law, while I have passed it here and made something a crime and so on, actually I can't even enforce it. Forget about outside of India, extraterritorially, But even within India, I can't enforce it because the technical means to enforce it don't really exist. If I don't know who committed a particular crime, for instance, of piracy, as the example was brought up, then how do I enforce that, right? Do I take draconian measures such as cutting off, blocking certain websites and from being accessed within my country because they won't comply with directions that have been legally passed in the country? So should we cut off Wikipedia if they refuse to abide by something globally because of some Indian law? And what if the company says, okay, fine, we abide by your law, but we'll abide by it locally? Should you say that, no, I don't, this law is meant to be applied extraterritorially? That means that not only can you just remove this content and make it unavailable for people within India, but you should also make it unavailable for people within India if they're using a VPN and making it seem as though they're coming from outside of India. Should we take enforcement to that level? Some countries have. So it's not for me an easy question. It's not easy to say that enforcement is always possible. And so on the issue of appointing grievance redressal officers and appointing chief compliance officer and so on, for me, one of the few good things about this law, and in terms of what a law like this ought to do, is to appoint a grievance redressal officer. Okay, you need to be able to have a human face to especially the larger companies, not necessarily all the small companies, because they might not have the wherewithal. Small services, not necessarily just companies, but they might not have the wherewithal. But at least what are called significant, social media intermediaries, they should have some kind of mechanism where you can reach out to a human being and not just through their various forms and so on. So for me, that is actually a good thing, even if not from a perspective of enforcing laws that the Indian government has laid down or says that you should put in your terms of service. At least in terms of enforcing their own terms of service, there needs to be a human being that you should be able to contact. So I think that's a good thing. Another point that Rajendra brought up, I think, was fantastic. There should be something in this, in a set of guidelines like this, about making your terms of service, if they exist, and especially if you are a significant player, available in multiple Indian languages, right? Even WhatsApp, which is probably the largest amongst all of these in terms of usage in India, doesn't actually have its terms of service available in the major Indian languages. And even if you take the largest Indian language, okay, Hindi, only part of the terms of service are available in Hindi. Like, well, how can we allow for that? That's ridiculous. Okay, and so for me, those kinds of things are things that should have been addressed. In some cases are to an extent addressed, and perhaps in some cases going overboard. But those are what should be addressed in a subordinate legislation of this kind. And on the general point about take it or leave it kinds of systems, you have to remember that a data protection law does not by itself prohibit these kinds of things happening. For instance, in California, they have a data protection law. So many countries across the world have data protection laws. But these changes that we are seeing on WhatsApp, those are happening in all those countries in any case. Sure, in some places in Europe, hackles have been raised, but even in India, you are free to say no to the privacy policy and abide by to the changes in the privacy policy and abide by the restrictions that are placed. You can still continue to use the service. And even now, for instance, while people may not realize it, to use a service like WhatsApp, you don't need, for instance, to give it access to your contact list on your phone. You can use WhatsApp perfectly fine without giving it access to your contacts. as well. You don't the kind of integration that they're trying to put in place between WhatsApp and Facebook. You are free to thwart that and still be able to use WhatsApp. And so I don't quite buy into the idea that a data protection law would magically resolve these kinds of issues. It might help, it would definitely lead to more legislation. But who needs a data protection law when you have PILs in India? Where every single thing you can conceivably think of will end up in the Supreme Court as a PIL. So we shouldn't really miss a data protection act all that much, if you ask me.
Thanks,
Definitely, the Supreme Court wields much more power than any data protection law could possibly. So,
thank you, Pranesh. I need to stop you on that because I think I've got a couple of prompters from the organizers in terms of time. It's been a phenomenal discussion and thought-provoking and stimulating, and I enjoyed every bit of freedom which the panelists enjoyed in terms of expressing their thoughts and expressing their views very clearly and with so much of authority. And I thank once again Mr. Rajendran, Ms. Napinai, and Mr. Pranesh for sparing their valuable time, and the IT committee headed by Ashok for facilitating this program, and Savita for coordinating some of the speakers. With that, I would hand it over to Saraswati, and thank you one and all. Unmute.
Sorry. It's an excellent session. I should join hands with Mr. Ishwaran to thank every one of you. Probably we should have planned it for a little longer, 2 sessions or 3 sessions, I guess. It has been so interesting and probably involving the thought process of everyone. Thank you so much, and I wish everyone a safe day. Maybe we will meet again to continue this discussion or on the data protection bill or act, whatever bill it's still. So we may have to have one more food for thought on that, I guess, maybe interlinking both. So thanks everyone in the meantime. Wishing you all a very safe, productive, happy weekend.
Thank you.
Ashok, you want to add anything?
That's all, madam. Thank you so much. It was a lovely session. Thank you all.
Thank you.
Thank you, and bye. Stay safe. Bye.